Don't forget to like, subscribe and share the videos.
Good evening to one and all. Welcome you all to the Daily Indian Express newspaper analysis for the date 13th February 2024, brought to you by Ganesh IAS Academy. Okay, before going into the newspaper analysis, I have a certain update with regards to the social media handles of Ganesh IAS Academy. Ganesh IAS Academy not only operates on YouTube channel but also in other social media accounts like Telegram, LinkedIn, Twitter, Instagram, Reddit as well as Snapchat, so where the current affair related updates as well as the competitive examination related updates will be posted regularly. So go and have a look into it. The link for the other social media handles description is given below in the description box. So go and have a look into it. Okay, let's get into the today's newspaper analysis. Mentioned here are the list of articles which we are going to have the analysis in the upcoming slides. So have a look into it. So these are all the articles which we are going to have the analysis in the upcoming slides. Jail and bail under UPA. So what is the situation of jail as well as bail under UPA Act? So let's look into the linkage of the news with the examination. So under prelims, the news is related to Indian polity and governance constitution. Similarly, under mains, it is related to GS paper 2 polity through a subtopic called structure, organization, functioning of executive and judiciary. This is how the news is being linked with examination. Okay, let's look into the details of the news. Bail is rule, jail is an exception. This proverb doesn't find any place in the UPA Act. Supreme Court has recently denied bail to Gurvinder Singh, who is accused in the Khalistan module case. And the bar for granting bail under UPA is higher when compared to the other ordinary criminal law. So let's discuss how the courts have interpreted the section 43D subclause 5 of the UPA Act, and also why do courts deny bail in most of the cases. So under section 43D subclause 5 of UPA Act, what it says is, notwithstanding anything contained in the code, no person accused of an offence under chapter 4 and 5 of this act shall be released on bail or on his own bond. So this is how the wordings have been formed under the subsection of the UPA Act. So what does it mean is, see, the law says that while relying only on the police version of reports, documents, the accused must show to the court that he is not an accused person, as said by the police report. So his sole authority or sole report which the accused should rely on is the police version only. So based on the police versions and fact, he or she should identify any malified or defuncts within the report, and he need to inform to the court that he has been framed in this UPA Act. So the responsibility of proving that he or she is not an accused falls in the accused itself. The Act shifts the, as I said, onus on the accused. The cardinal principle of the person is innocent until proven guilty is appended under UPA Act, and the narrowing room for the bail. So 2019 Supreme Court bench ruled in Zahoor Ahmed Shah Watia versus NIA case. In short form, it is Watia versus NIA case. What it has ruled is that for granting bail under UPA Act, the courts must not examine the evidence but only have to accept the evidence that has been produced before. The court also said once charges are framed, accused have to undertake an arduous task of satisfying the court that the accusation made on him is not true. So the sole burden of proving that he or she is not an accused falls on the accused itself. So the legal scholar, what they are saying is that the lawyer of an accused in the UPA case arguing for the bail would be like participating in the swimming competition with both arms are tied. So this is what the proverb some legal scholars are giving. And post watali ruling, that is the post ruling, what are all the sequence of event that has taken place is, it closed the windows for the trial courts to look into the prosecution or the reasonableness of the prosecution. If the prosecution case is flimsy or some other thing which has certain defects in it, means the court could not question it. It raises concerns on the liberty of the individual. This is what the post case. These are all the situation that has arisen post the Watali ruling. And the Delhi High Court has recently granted bail to 3 student activists who have been participated in the anti-CAA protest. The court, what it said is that, see, specific and individual charges must be made out by the prosecution and not the broad speculation and inferences. But this order have been, however, been stayed by Supreme Court. Similarly, Bombay High Court also granted bail to the right activist, simply referred to the material before it and found there is no specific linkage to the act by the activist. And similarly, in 2021, Supreme Court also granted bail to a person under UPA when the accused have undergone incarceration for the significant amount of time period. So these are all the different instances where the bail have been granted under UPA Act by the different high courts as well as the Supreme Courts. And Supreme Court in Vernon Gonsalves v. State of Maharashtra, in 2023, what it has said is that, see, it differed from the Watali judgment, and what it says that the prima facie test, what the Watali judgment has given does not apply. It would not satisfy the prima facie test unless there is at least surface analysis of the probative value of the evidence. So this is what the judgment. So basically, the judgment differed from the prima facie test or the procedure to be followed in the prima facie test that has been ordered by Watali. So the Gonsalves judgment differed from it. Both, as I said, Gonsalves as well as Watali differed from it, but both of them have the benches with same strength. So it will have, so if a particular bench is making any kind of judgment, means then that judgment will be overcome only by the bench which is having the more number of strengths when compared to the previous bench. But in this case, both the benches are having same amount of strength. So it is, so what is the future consequences or the future thing that is going to happen will be decided only in the future only, or by the larger bench of the Supreme Court, larger than the Gonsalves as well as Watali ruling. So this is what the thing is. What need to be studied further is, we should be aware of the recently passed Bharatiya Nyaya Sanhita Act as well as Bharatiya Nagarik Suraksha Act and then Bharatiya Sakshya Bill. So these are all the things which we needed to be further aware of. Secondly, we should also be aware of what is NIA and what is ED, their structure, function and objective and the ministry under which they are coming. Thirdly, we should also be aware of FERA and FEMAC and the difference between both of them. So these are all the things which we needed to be further aware of, and with this we have reached the end of this topic.